Let's give a round of applause for Michelle Lerman.
Thank you. Did he say my topic is boring? I think he said it's boring. And I'll tell you something else. When I got the call that I was getting this award for being the #1 favorite attorney in Marin and Sonoma, I called him up and I said, Jeff, you will not believe it. Have you ever heard that there's a poll, that a magazine actually does a poll to nominate a favorite lawyer? I said, well, I just got this phone call and I won. I wasn't just nominated, I won #1 favorite lawyer for Marin and Sonoma. He said to me, honey, I think you got it all wrong. They meant that you were married to the #1 favorite lawyer. So not that there's any competition whatsoever between us. Actually, one of the things that we do very well is our firm is branded as the Real Estate Investors Law Firm. And Jeff told you all about me and bragged about me, and I'm a certified specialist, and it's true, I do love what I do. But let me just tell you a little bit about my partner, because anything to do with real estate, Jeff is really the go-to person. Real estate entity formation, leasing, asset protection. In fact, even the news, if they have a story on real estate, this is the guy that they call. So, past president of the Marin County Bar Association, he is the best partner in life, and he's the best partner for my law firm. So I'm thrilled to be with my husband in partnership in life and in business. So with that, am I the only one that senses confusion over estate tax issues? So I feel like there's so much confusion and so many questions, we could probably spend the next hour asking questions, but maybe we should get started in answering some. So to start, let's see, let me start, since everyone is wondering about the changes in the tax law, let me look into my magic crystal ball and tell you what's going to happen. Unfortunately, it's not that simple. We have unprecedented confusion, and I want to start by just talking about where have we been and where are we going. First of all, anything you hear, there's a disclaimer, because you really need the advice of a lawyer. If I tell you, Paul, was it? If I tell Paul, yes, the exclusion amount, you can use the $5 million for gifting, I don't want you to run out and gift $5 million. I want you to engage an attorney and really figure out all the details of the rule. So no attorney-client relationship yet. I hope, quite honestly, and statistically, a lot of you will become clients, because this is step 1, listening to information. Step 2 is the consultation. What do we do now that we have this information? So we will have an opportunity to sit down. Once you sign an attorney-client engagement agreement, that's when there is a connection and a relationship and an attorney-client relationship. So really critical, just don't run out and do these things that we're talking about today. Make sure that you get the right advice. So where have we been? Well, I'll tell you, some of us missed a great opportunity in 2010. We didn't die. Of course, I'm only joking when I say that, because there's nothing more precious than life. But in 2010, someone could pass away and there's no estate tax in 2010. So what the current law says, that you can go back to that if you have loved ones that did pass away and actually elect to be governed by 2010 laws. But if you don't elect for 2010 laws, then we have a $5 million exclusion, as you can see right here. We have a $5 million exclusion. So if at any time I say something and you're like, this is confusing, I have no idea what Michelle is talking about, just raise your hand. And if you want to just raise your hand and not even answer a question, ask a question, I will go back and clarify what I just said. So you don't have to be embarrassed, because quite frankly, this can be complicated, but I want to speak to you today that everyone here should be able to understand. And if you're not understanding, just give me a quick like this, and I'll look around and then I'll repeat what I'm saying. So just to cover some basics, what is a $5 million exclusion? Anybody? What's a $5 million exclusion? Right, so when you pass away, the first $5 million, there's no estate tax. We call it an exclusion. It's logical, right? It's excluded from estate tax, the first $5 million. What does it mean that the $5 million exclusion is also excluded from gift tax? And Paul, that was your question. What does that mean? Sort of the same, but in a way what you're going to learn today is it's actually very different. Because the $5 million exclusion, you can gift that during your lifetime, file a gift tax return, and there's no tax on that transfer. There is no gift tax on that transfer. And we're going to focus today on what the advantages are and what the opportunity is. Why give $5 million today if you can wait until your demise and give the $5 million? Why do it today instead of doing it upon your demise? And the answer is that there's a huge opportunity for doing it during your lifetime. And that's the opportunity that we're going to focus on today. And lastly, what I want you to know about the current state of the law is that there is a sunset. Who was it you asked? Is there a sunset? Yes. Tiffany, is it right? Tiffany said, what happens? Is there really a sunset? Let me explain what I mean by the sunset. Literally, what it means is that the law goes away. It sets like the sun. But instead of like the sun, where the sun comes back up the next day, this law really doesn't sunset. You could say this law more like dies. It just goes away. So the current law is set to last all of this year, and at the end of this year, it's set to go away. By January 1st next year, we have a completely different scheme. So there's a window of opportunity. What's going to happen between now and the end of the year? Gee, now we've got a horrible deficit problem. We've got a government in need of money. We've got an election year. You tell me, what's your guess? Do you think that our current government is going to act to raise taxes or lower taxes? Or do nothing, right? And if they do nothing, it's going to default to raising taxes, because the exclusion amount starting January 1 next year, if nothing happens, the exclusion amount goes from $5 million to $1 million. That means that if someone passed away next year, they can only leave $1 million free of estate tax. But if someone passed away this year, they could leave $5 million of estate tax. So a lot of you asked me, what do I think is going to happen? There's only one thing I'm certain of. You want to hear the one thing I'm certain of? I don't know. That's the only thing I'm certain of. And the other thing I'm certain of is anyone who tells you that they know, they really don't know, because the entire estate planning community was completely shocked that there was ever 1 year of estate tax repeal. We were shocked. Everyone thought that there was going to be a law passed so that 2010 tax law repeal would never have taken effect. Everyone. So in January we said, they're talking about health care, nothing happened. February, nothing happened. We already got to the summer, nothing happened. And all of a sudden, before we knew it, it was January 1st, 2010, and estate taxes were completely repealed. That's why I was joking we missed an opportunity in 2010. For those people who passed away in 2010, there were no estate taxes. George Steinbrenner, you name it, millionaires, billionaires passed away. There was no estate tax if someone passed away in 2010. So I was a history major in college, so I always think that you have to study history in order to know what's happening in the future. And that's why I say there's only one thing I know for sure, and that is that I don't know. Because we were all wrong. We all thought for sure estate tax repeal wouldn't happen, and it happened. So that's where we're at now, and I want to just go through the agenda. Go ahead.
I just wanted to ask, I'm not sure if it's part of this topic, but will you be addressing the option of grats?
Yes, the question was, am I going to be discussing the option of grats? And the other thing is that we are recording this talk. So if there's something that you want to ask me a question about, so far it's just been very general in nature, but if there is something and you don't want that on a video, you should save that for our complimentary consultation, because this talk is being videotaped and I don't want any of your confidences being revealed. So, okay, let me tell you what we're going to talk about today. I've divided the talk making a very complicated subject matter into 3 distinct sections. The first section, we're going to talk about what the New York Times has referred to as a gift tax bonanza. We're going to talk about, like Paul mentioned, this $5 million that you can gift it during your lifetime, and we're going to talk about what an opportunity that is and how to exercise that opportunity through something like a GRAT. So I'm glad that you asked that question. Then we're going to talk about portability. Portability can sound confusing. When I was speaking the other day, he called it potability. No, we're not talking about water and drinking water and purifying drinking water. And I'm going to explain what is portability, and does it mean that you need to change your current estate plan. And then the third part of the talk, we're going to get back to basics. I have Mark Farrelly here from New Focus Financial. We brought Union Bank here. We've, throughout the room, you'll see people from Bernstein here, people from Fidelity here. So it's good to mingle and meet different people, because this is really a time to establish a team. You're going to want a great CPA, you're going to want a great lawyer, you're going to want a good bank to work with, you're going to want a good wealth manager. It's hard enough for the professionals to figure out what to do. You need to really have a team. So the third part of our talk, I'm going to have Mark Farrelly talk to you for a few minutes from New Focus Financial about wealth management and what you need to do. And then we're going to talk about estate planning and say, what are the next steps? I've left here. Michelle made it really clear. She simplified a very difficult topic. But now, what do I need to do? So we're going to really walk out of here with concrete steps. How's that sound? Good program. So, gift tax bonanza, the extra $8 million. The gift tax bonanza, as I referenced, was something that the New York Times coined. That was a term in the New York Times referring to this new law, because you can use the $5 million of exclusion during your lifetime. Why is it a gift tax bonanza? Because there's no gift tax if you gift up to $5 million during your lifetime. So why do I say $8 million? Do you see on the screen here it says an extra $8 million? Why 8? I said that you could leave $5 million and that was the exclusion amount. Where did we get 8? Anybody?
Would that be the portability?
No, not portability. We're going to discuss that next. But good guess. I like that. I like that. She asked if it was portability. No. Pardon me?
Couples.
Couples, because you're close. I feel like I'm doing Jeopardy. Charades.
Can do the gifting.
Because each person, when you're a married couple, each person has an exclusion amount. So my husband and I, he has an exclusion amount, I have an exclusion amount. Each single person has one exclusion amount. But a married couple has 2 exclusion amounts. So if my husband had $5 million exclusion and I had $5 million exclusion, how much can we gift during our lifetime together? 10. We used to be able to only gift 2, because the exclusion amount last year, not 2010, but right before 2010, right before the estate tax repeal, the exclusion amount was $1 million. So as a couple, what is it as a couple when it was $1 million? $2 million. So the gift tax exclusion used to be $2 million, now it's $10 million. That's the extra $8 million. Okay? So I've said that you could gift $5 million per person. There's no gift tax. You file a gift tax return. You use your exclusion. But why? Why gift now? And that's what I want to talk about, because it's like your estate is going through a funnel. And here you are living, and you've got this funnel. And all of your assets are in your funnel. But to the extent that you gift during your lifetime, then upon your demise, there's fewer assets and less estate tax, because you've reduced your assets. You've gifted. And so the idea is to give early and give a lot. That's the idea. Give early and give a lot. So,
Question.
Yes, go ahead.
If you give the assets, would you have control of the assets?
The question is, if you gift the assets, would you have control of the assets? Generally, no. Because if I gift something but I keep control over it and I use it, the IRS is smart and they'll say, you kept control, and under a code section numbered 2036 or several other related code sections, the IRS says, you didn't really gift that. And when you pass away, if you kept that kind of control, use, and possession, it gets pulled back in your estate. So it's not really a gift. So you do have to give up control. Yes?
Gift it now, and does that mean that I cannot exclude it later?
So when you gift it now, it already is. The question is, if I gift it now, do I have to exclude it later? Okay?
Can I exclude it?
Can I exclude it later? If I gift it now, can I exclude it later? You already did exclude it later because it's gone. You don't own it, and I'm going to clarify, it'll become more clear. But once you gift it, it's gone. It's no longer yours. If you pass away and you've already gifted it, it's no longer yours. Right?
Do I get a $5 million exclusion if I die this year and if I gift it?
Right. So the question is, if I gift it now, do I still get to keep my $5 million exclusion? For example, can I use $5 million in exclusion to gift it? And when I pass away, do I still have a $5 million exclusion? What do you think the answer is to that question? No, because as I said, you file a gift tax return and you allocate, you use some of your exclusion to that. So if during your lifetime you gift $1 million, then when you die, you have less as an exclusion amount. So someone looking at that and said, okay, so why would I gift? Right? Why would I gift? If it reduces my exclusion amount when I die, why would I gift? Now, is everyone following that concept? Because that's something really important. I think I'll give you a quick example. Let's say that you gifted $1 million and then you died the following year. And let's say when you died, that the exclusion is $5 million. You gifted during your lifetime. You gifted $1 million, you filed a gift tax return, you used $1 million of your exclusion. Here's my question to you. Does everyone understand the question? Shall I repeat it? You've gifted $1 million, you pass away, and the exclusion is $5 million. How much exclusion do you have left if you filed a gift tax return using your $1 million exclusion? 4, right? Because you have to subtract what you already used during your lifetime. So you could say, okay, if I could leave it now, if I could gift it now, or if I could gift it during my lifetime, or if I could wait until my demise, what's the difference? If it subtracts what I can do at my demise, why do I need to gift it now? And that's what we're going to go into. Question?
If it sunsets from 5 to 1 and you give $1 million this year, you're done.
So the question is, if it sunsets and it's $5 million exclusion now, and next year the exclusion amount goes back down to $1 million, and if you go ahead and gift $1 million, he asks, is it done? In other words, do I still have more exclusion? No, you're done. You gifted your $1 million, and if the exclusion amount when you die is $1 million, you've already used it. Okay? So I want to use as an example, there's something called a qualified personal residence trust. So this next part of the talk is really critical because it really is an opportunity of a lifetime. And what I'm going to show you is that when you gift during your lifetime, that $5 million exclusion can be worth a lot more than if you wait until your demise. That's so important that I'm going to repeat it. If you gift $5 million during your lifetime, you can make that gift worth much more than $5 million. It is better, there is a savings to gifting it during your lifetime rather than waiting till your demise. So I'm going to talk for a minute about a qualified personal residence trust. Now again, this is confusing, but remember this is only step 1. Step 2 is the consultation. So if any of these sound interesting to you, just make a note. Say Cupid and there you go. Thanks. So just say Cupid, and then I'll explain that to you in more detail. So let's say that this is the deed to my house, and your name is?
Linda.
Linda. I'm going to give Linda the deed to my house, and let's assume that my house is worth $5 million. And I'm going to give it to her now during my lifetime. By the way, I picked Linda to give this to because last time I handed the deed to my house to someone, it was a man, and he asked if I come with the house. So Linda, I don't come with the house. Okay?
Take the house.
She'll take the house. Gee, thanks. $5 million house. $5 million house. I'm giving the deed to Linda during my lifetime. I want to use my exclusion amount, so I have to file a gift tax return. I have to allocate my exclusion to it, right? I said you can use it during your lifetime or upon your demise. You file a gift tax return. You use your exclusion. It deducts from what you can use at your demise. How much of a gift did I give? I handed Linda the deed to my house for $5 million today. It's hers. I gifted it. How much of a gift is it?
2.5. You're married?
Whatever the value is when you die.
When you die.
Is that what it depends on? So that he said it depends what the value is when you die.
Stepped up basis.
And this gentleman says stepped up basis. Who else? Who can tell me, do I have any CPAs in the room? Who can tell me the amount of my gift if I give Linda the deed to my $5 million house today and I say, Linda, it's yours. Give me an hour to move out. It's yours. How much of a gift did I make? It's actually a really straightforward question.
$5 million.
It's $5 million. There's the house for $5 million. I'm giving her immediate a gift of the house. It's a $5 million gift. Now, let's say, your name again was?
Dan.
Dan. Now, give me 1 minute. Now, let's say the deed to my $5 million house, I'm going to give it to Dan as trustee of a trust for the benefit of Linda. Got it? I'm giving the deed to my house to Dan as the trustee of a trust. A trust is just an instruction manual for what I want Dan to do with my house, and as the trustee, he's the one managing it. Okay? He's the trustee. Dan, when after 5 years, I'm instructing you to give that deed to my house to Linda. It's a $5 million house. Dan, I'm going to live in my house for 5 years, and after 5 years, at the 5-year mark, my instruction manual, that trust, is going to direct you to go ahead and transfer ownership to Linda. 5 years passes and now Linda gets it. But the gift is when I put it into the trust because it's an irrevocable trust. I cannot change it. That trust has a separate tax ID number. That trust is not me. That is a gift. So my $5 million house that I'm going to live in for 5 years and then it's going to go to Linda, how much of a gift have I made?
Great.
$5 million.
Linda thinks $5 million. Is it $5 million?
No, whatever the value of the asset is.
So what he said is whatever, I'm not sure if this is exactly, but I'm going to paraphrase because the answer is right. The gift, I get to subtract the value of my living in the house for 5 years. Right? Because I'm not giving Linda the right to live in the house now. I'm keeping something. That something has value. And there's actually a table that tells us what the value is of that asset. So when I go to file my gift tax return, yes, my house is worth $5 million, and I'm going to gift it today into this qualified personal residence trust. But when I file the gift tax return, I don't have to say that it was a $5 million gift. I get to subtract the something that I kept, the value of me keeping it for 5 years. So that's why it can be better to go ahead and gift the house now. Now I say can be because it's complicated. If I bought this house for only $1 million and it appreciated a lot in value, when Linda eventually gets this house, these are some things I'm just telling you because I don't want you to go away thinking I'm going to go do a Cupid. I want you to understand that there are some ramifications that you need to know about. The basis of the house is still $1 million. So that if Linda later sold the house and it's worth $5 million, she's going to have to pay tax on the gain. It's not gift tax, it's because she sold it and there was a gain. So it might be a great thing to do for the right situation. Whether it's right for you, I couldn't tell you yet. But where we often, give me 1 minute, where we often use this is in a married couple situation where one spouse has already passed away. When someone passes away, and again, you're not going to understand everything that I'm saying the first time I say it here, but I will follow up with you when we meet in person. There's something called a step up in basis. A step up in basis. And when someone passes away, the basis of property gets stepped up. What does that mean, just in simple terms? What it means in simple terms is that my $1 million house, if I die with a house that I paid $1 million and assume my tax basis is $1 million, if when I passed away my house is worth $5 million, my heirs get a step up in the tax basis from $1 million to $5 million. And why do you care? Because then the kids can sell that house and there is no gain because they're going to sell it for $5 million and they get a step up in basis for $5 million. But if you gift an asset during your lifetime, generally the people that you're gifting it to, they're going to get it at your low basis. So you have to be careful. You have to weigh income tax and you have to weigh possible estate tax savings. The other thing about a Cupert is I have to outlive the term of the Cupert. If I do a 5-year Cupert and I say, Dan, hold this and in 5 years give this to Linda, if I should pass away in year 2, the house is still in my estate. I haven't gifted anything. Is that clear? So, but the idea is to pick a term of the Cupert that you think is likely that you're going to outlive. Obviously, if I only keep the house for 2 years, I'm making a bigger gift because the something that I'm keeping is worth less. Whereas if I put this in a Cupert for 10 years, I'm keeping 10 years worth of the use of this house, so I'm making less of a gift. So you just have to sort of balance how that is gonna work. But you can see that possibly gifting now, you could use only a fraction of the gift tax exclusion that you would use if you waited until your demise. But not only that, it gets even better. When I gift this, I then have to start paying rent because I don't own it anymore. So after the term of the Cupert, I have to start paying rent. Guess what? That gets more money out of my estate because then I can continue to pay the rent. So a Cupert is something that I just want you to know about, because what if if I didn't gift it now, what if my house appreciates even further? And then upon my demise, my $5 million house is now worth $7 million. It's out of my estate. So it gets assets out of your estate, let it grow in the estate of your family. So you can understand the benefits of gifting during your lifetime instead of waiting until your demise. So it's a really important concept, and we're going to just briefly mention other types of gifts. There's a GRAT, there's a life insurance trust, there's an installment sale, there's a family partnership. Looking at your assets, we can determine whether you should gift, and then we can advise you what the pros and cons are of the various kinds of gifting. But this kind of gifting all has one thing in common. It leverages the amount that you can leave so that when you gift it during your lifetime, generally your exclusion amount is worth more. Either because you're going to retain an interest or because, like, life insurance is a great example. Who here sells life insurance? Do you guys do, you do life insurance? So let's say that you bought a life insurance policy. It's going to cost a lot less than the death benefit to buy the policy. So for example, how much would it cost, do you think, if I wanted to buy $5 million of insurance? It's not going to cost $5 million. Typically that's the whole idea of insurance, is that it's going to cost you less. But the gift that you're making, I could gift that policy to Linda. I could gift Linda $1 million. She could buy a life insurance policy for $5 million. But how much of a gift did I make? $1 million. So it leverages the exclusion, and yet I've transferred $5 million or whatever the insurance. And by the way, that's just an example. I have no idea what the premiums would actually be, but the idea is the premiums are going to be less than the death benefit that you're going to receive. So I'm going to take some questions about this because this is a window of opportunity. Who should act? Anyone who knows that you're going to have a taxable estate upon your demise is going to want to look into gifting now. And most important, though, is that you have enough assets to live off of, right? You don't want to gift something that you're going to need because once you give it, you give it. So that's really important. Yes?
So the QPERT is specifically for your personal residence?
The question was, the QPERT is specifically for your personal residence, and the answer is yes. It's specifically for your personal residence. Other questions? Yes?
Yeah, you mentioned on the QPERT that the basis stays the same. Does that play a part with the real estate taxes as well? So like if you're gifting that in and then she takes possession of the house 5 years later or whatever, is the basis for the real estate taxes the same as when you had it?
Right, so the question is, if the tax basis when I give that house, remember I bought it for $1 million and now it's worth $5 million, so we just made an assumption that my tax basis was $1 million because that's what I paid for it. So we said that when it goes into the QPERT, the tax basis is $1 million. That's an income tax issue. That determines whether Linda can sell it and whether there's a gain or not. Your question was, what about the property taxes? Because property taxes have an assessed value, and in California, when there's a change of ownership, property values are reassessed and property taxes go up accordingly. And the question is that those are completely different topics, and even though I paid $1 million for property taxes, that may or may not be my assessed value. So you have to look at what the assessed value is, and typically I'm going to transfer it and it's going to be for children, so the parent-child exclusion would apply. Because if you transfer real property to children, it can qualify for an exclusion so that your property taxes don't go up. And there's different rules for that, and there's different limitations, but in general, parent to a child for property, in general, there's a way for at least part of it to be excluded from reassessment so that your property taxes that you pay every year, twice a year, those stay the same. So I'm glad that you mentioned that. There's basically 3 different types of taxes that we're talking about. We're talking about income tax, we're talking about estate tax, and we're talking about gift tax. And then there's this other tax that we're also talking about sometimes, which is property tax. So those are all distinct issues that we really need to be able to separate. Was there a question over here? Yes, and then I'll get to you.
With respect to QPERT, what happens if your personal residence is a multi-unit building that you own but also reside in? How does that play out?
That's a good question, and I'll talk with you more about that. Because with a multi-unit residence, there's going to be a lot of different issues that come up. And it may not be suitable for a qualified personal residence trust because you can't just divide the residence. A QPERT is for a residence. So when you have, the question was, if I have a multi-unit building, and I live in one of the units, can I still do a QPERT? So you can't do a QPERT for an apartment building, and if you only live in one of the units, it probably isn't a separate ownership. So you probably, I'm assuming, could not do a QPERT for that. But if that's of interest to you, when I meet with you, we can talk about that more. Yes?
On the QPERT, if you want to stay in there for a period of time, do you have to delineate a specific number of years? You can't say that you can stay there.
Right, so the question is, if you want to do a QPERT and you want to live in the house, do you have to, and you don't know how long, do you have to delineate how long the QPERT is? You have to delineate how long you're going to stay there. Well, the beauty of that is that yes, you have to delineate how long the term of the QPERT is, But you can stay in the home indefinitely after that because all you have to do is pay rent. And it's good to pay rent because that's a way of getting more assets outside your estate. Yes?
Is your mortgage holder going to allow you to transfer title?
Is your mortgage holder going to allow you to transfer title? We typically don't do a QPERT with encumbered property. We typically do a QPERT with unencumbered property. So if there were a loan on it, that probably isn't such a good candidate for a QPERT. I've done it before, but we don't typically do it. So we would want to look at that, and then we've got to deal with lender and approval and all that. Yes?
Well, looking at gift horse in the math for a moment, when you do this QPERT with Linda and she goes to sell the property, isn't she saddled with the gain?
So the question is, if I transfer $1 million house to the QPERT and then it goes to Linda, and if Linda wants to then sell the house, isn't she saddled with the gain? And yes, that's the point that I was making, that it may be better to wait until one spouse passes away so you get a full step up in the basis, and then you transfer the house to the QPERT, because otherwise you're right, if she goes to sell it, then you've got a gain issue that you're going to want to talk to your CPA about. Yeah.
On a paper profit.
Well, it's not a paper. The question, then he followed up and said it's a paper profit. But if Linda actually sells the house, that's a real profit because she has the house and she sold the house. So that's a real profit. Any other questions on? Yes. On second homes, that's a possibility to do it on a second home. It's a possibility, but typically it's a qualified personal residence trust, so typically we would do it with the primary residence. Other questions? Yes?
Even if she's so-called saddled with the gain, it's still considerably less than the inheritance tax.
So the question was, even if Linda is saddled with the gain, maybe it's still considerably less than the inheritance tax. And that's the calculation that has to be made, is it? And so that's what we look at, and that's why I say, please don't run out and put your house in a QPERT and try and figure out how to do it by yourself, because it's very complicated. We have to weigh how much inheritance tax are you likely saving and how much potential capital gains are you subject to. So we have to balance. Any other questions on that before we move on? Yes?
Can Linda be the spouse only, or can it be
Linda,
somebody else?
the question is, can Linda be the spouse only, or can it go to someone else? Typically, you're going to do a QPERT with your children. So typically, Linda is my child. She's 18, I'm 53, and she's my child. Yes. Any other questions before we move on? Yes? Okay. So portability, not potability, portability. So let's simplify this concept that, that can at first blush look complicated. So portability means what? Just in the dictionary, what does portability mean? Movable. Movable, good. Portability means movable. So it used to be that when one spouse passed away, everyone has an exclusion amount, and when one spouse passed away, that spouse would either use the exclusion, or lose it. It was gone. In other words, if one spouse passed away this year, and everything went to the surviving spouse, and the surviving spouse then passed away 10 years from now, the surviving spouse couldn't use the first spouse's exclusion amount. It was either use it or lose it. So what did people do? And I'm going to back up. What did people do? Well, that's the typical reason why you have what's called an A and a B trust. And I'm going to show you a chart of how to use an exclusion. So typically, if my husband passed away, instead of giving everything to me and outright letting me do whatever I want with it, typically he would say, Michelle, you can have it, but I'm going to give it to you in two trusts. One trust, just to keep it simple, we're going to call it Trust A. One trust, we're going to call it Trust B. And everything that went into Trust B is his exclusion amount, so that when I later die, that's not even counted as part of my estate for estate tax purposes. It's not even counted. So let's just take a really simple example, because I see some faces that are like, I'm not sure I'm following this. $2 million estate. My husband and I have $2 million, and he passes away. He passes away. When we form our trust, the trust is going to say that $1 million goes into Trust A and $1 million goes into Trust B. Remember, a trust is just an instruction manual? So there's one instruction manual that the name of that is Trust A, and there's another instruction manual, and that's Trust B. Let's say that I pass away 20 years later. I pass away 20 years later. So when he died, tell me where the assets went. We had $1 million in Trust A, right? And we had $1 million in Trust B. Good. You're with me so far? So now I died 20 or so years later. That $1 million that was in Trust B, let's say that it grew and grew and grew and grew, and let's say that it became $3 million because I invested it so well. I invested it so well, and it became $3 million, and then I pass away. Here's the point of this conversation. The B trust is not subject to estate tax when I pass away. That was his exclusion amount. That was his $1 million that grew and grew and grew. That's what I mean by using it. You use it by putting it in a special irrevocable trust. You can also use it by giving it to kids from a prior marriage. But if you didn't use it, you lose it. The surviving spouse can't just use your exclusion amount. Here's what changed. In comes this new law. And what changed is now under the new law, if I die years later, I can use my husband's exclusion amount that he didn't use. I can use, so if the exclusion amount were, say, $2 million, I can use the entire $2 million exclusion and not pay any estate tax when I die, even if I didn't have a B trust. So what does portability mean in the dictionary?
Your kids would.
Pardon me? Exactly. The kids wouldn't have to pay any estate tax when I die. So what does portability mean? Movable. That exclusion amount is movable from one spouse to the other spouse. Okay? So let's just say, question.
So if the whole AB trust, if you didn't have it and just put the whole $2 million in the initial example into one trust and essentially commingled it, for lack of a better word, does that mean that you, if that $1 million is the splitting into the separate trust the only way to earmark that exclusion, or can you earmark it even if it's commingled?
So in other words, what Jeff is asking is the only way to use the first spouse's exclusion by putting it in a B trust? Putting it in a B trust the answer is yes. If you want to give it to a spouse, you would use it by putting it into a B trust. But you could also give it to your kids. But you can't just give it to your spouse and, as he mentioned, commingle it. You can't just give everything to your spouse. For example, let's say that there is Dan and Ann. And let's say that they live in this house and they have an I love you will. I call it an I love you will because if one spouse dies, everything just goes to the other. And Ann dies and Dan remarries. So when Ann died, it was, as Jeff mentioned, commingled, so to speak, right? Dan could do whatever he wants with it, and Dan remarries Sue. When Dan remarries Sue, let's say that he later passes away. If he passes away and everything is commingled, he didn't use the exclusion amount by putting it into a B trust, who gets the assets? Who gets, as Sherry mentioned, this husband and wife, who gets the husband's share, who gets the wife's share? Who gets the assets?
IRS.
The IRS. No. Sue. So the reason that I point this out is because although you don't need to have that B trust, you can, as Jeff says, commingle it all and have an I love you plan and leave everything because of this portability. Perhaps you think I'm just going to give everything to the survivor because use it or lose it isn't the law anymore. I want you to think about Sue, because the irrevocable trust for your spouse can be a way to protect your assets from a sue. And I get to know people as they come to these talks and they tell me their name and I answer their questions. And one time someone came into the office for the consultation and I knew that her name wasn't Sue, but she said, "I'm Sue." That really, really happened. And I'm not saying never leave it to a second spouse. In that situation, they'd been married 40 years and it was a second spouse. I just want you to realize that there are non-tax reasons for having an estate plan. And that's what I want you to realize, that there are non-tax reasons. Sue might be a non-tax reasons. Even with portability, you don't need a B trust, but you might want to think about whether you should have a B trust. Yes?
Is another name for the B trust that you're using a bypass trust?
So the question is another name for the B trust a bypass trust? Yes. So a B trust is also referred to sometimes as a bypass trust or an exemption trust. So far we've talked about this gift tax bonanza. I'm just going to ask you a couple questions to make sure you've all followed along so far. So if you leave $5 million upon your demise, is that the same as leaving it now and gifting it during your lifetime? Is $5 million gifted now equal to $5 million waiting until your demise? No, because you can exponentially increase that amount by doing something like a QPERT or a GRAT or an installment sale or leveraging it with a life insurance trust. And there's other ways, and we're going to talk to you about in your consultation. Do any of those ways make sense for you? Portability is a big aspect of the new law. It just means the exemption is movable. In other words, if the first spouse dies and doesn't use it and doesn't set up a B trust, the surviving spouse can still use the exemption. It's not wasted. So if the exemption were $2 million and my husband didn't use any of his, I can use his years later even though he left everything to me. But because of Sue, that might not be such a good idea because there are non-tax reasons for having your plan.